Negotiable Instruments Act, Section 86, Parties not consenting discharged by qualified or limited acceptance. Section 86 of the Negotiable Instruments Act, 1881 deals with the legal effect of a qualified or limited acceptance of a bill of exchange and protects prior parties from being bound by an altered acceptance given without their consent. The section provides that where the holder accepts a qualified acceptance without obtaining consent of previous parties, such parties are discharged from liability against the holder and persons claiming through him. 1. General principle of the section. Ordinarily, a bill of exchange is expected to be accepted according to its original terms, but where the drawer gives a qualified or limited acceptance containing modifications or conditions and the holder agrees to it without consent of earlier parties, Section 86 discharges those parties from liability. 2. Meaning of qualified acceptance. A qualified acceptance is one that alters the original terms of the bill relating to payment, amount, place, time, or responsibility for acceptance, and the law treats it differently because it changes the risks and obligations of prior parties. 3. Acquiescence by holder. The section applies where the holder acquiesces in or agrees to a qualified acceptance, whether by express agreement or conduct, and once the bill is taken with the modified acceptance, the consequences under Section 86 come into operation. 4. Effect on previous parties. The section provides that all previous parties whose consent to the qualified acceptance was not obtained, including the drawer and prior indusses, are discharged from liability against the holder and persons claiming under him. 5. Reason for discharge of previous parties. The law discharges previous parties from liability where a qualified acceptance materially alters the risk or terms of payment, since they never agreed to be bound by the modified conditions. 6. Consent of previous parties. The discharge applies only where prior parties have not consented to the qualified acceptance, and their liability continues if they assent to it after receiving notice of the altered acceptance. 7. Notice and subsequent assent. The section further provides that prior parties are not discharged if, after receiving notice of the qualified acceptance, they assent to it and agree to continue their liability under the modified arrangement. 8. Qualified acceptance by one of several drawers. The section provides that where several drawers who are not partners are involved, acceptance should ordinarily be signed by all of them, and any incomplete acceptance is treated as a qualified acceptance that may discharge previous parties if accepted without their consent. 9. Conditional acceptance. An acceptance is qualified where it makes payment conditional upon the happening of a specified event, thereby introducing uncertainty into an obligation that was originally required to be unconditional under the bill. 10. Partial acceptance. An acceptance is qualified where the drawer agrees to pay only part of the amount stated in the bill, such as accepting a bill of 1 lakh rupees for only 60,000 rupees, thereby materially altering the obligation and affecting the liability of prior parties. 11. Acceptance as to place of payment. An acceptance is qualified where it changes the place or time of payment under the bill, thereby altering the original contractual terms and affecting the liability of prior parties. For more details, contact us.